just days after U.S. Supreme Court signaled former President Donald Trump would speed up assessment his alleged inviolability to prosecution for alleged crimes in office. It said, he agreed to decide on another important question arising from events of January 6, 2021, those involved in disrupting endorsement Joe Biden's 2020 election victory that day. Can he be charged under a federal law criminalises preventing a formal congressional process from corruption? More than 300 defendants, including Trump himself, face such charges. The headlines in a row mark the beginning of a new stage in Trump's complex legal adventure. At this stage, the High Court, with its 6th conservative majority, could delay Trump's upcoming federal election meddling trial. It will even take steps that can derail. The judges will decide scope of the blocking charge at center of Trump's case. Key players. Special Counsel Jack Smith, U.S. Supreme Court. The 6th of January defendant Joseph Fischer Two of the 4 charges in the federal election interference indictment against Trump are based on a 2002 law that emerged from Enron's downfall and made it illegal to block an official transaction. Smith accused Trump of personally blocking the certification process to be held at the Congress building on January 6 and conspiring with others to prevent it. Blocking accusation to change, destroy, disrupt, hide a record, document, other object, impede, influence, impede any official transaction in any other way with corruption. The 6th of January is one of the most widely used heavy crimes for prosecutors who require up to 20 years in prison for one person. According to the Associated Press, at least 152 rebels were convicted in court or pleaded guilty to obstructing an official process, of which at least 108 were sentenced prison. But Fischer's lawyers, a former police officer who turned a rebel, Pennsylvania, are trying to deny obstruction accusation, saying the original law in 2002 was designed to ban destruction of company documents cases of financial misconduct. In April, a federal judge passed Fischer's denial request, saying the law required the defendants to take some action in relation to a document, record, or other object, after appellate court overturned that decision by ruling that the law statifies to prevent any official case from corruption. Fischer's lawyers appealed to Supreme Court, looking for clarity. The Biden administration urged judges to see the case. Why it matters. The Supreme Court's decision to accept case suggests that at least 4 judges believe there is a legitimate argument against the application of blocking law in 2002 to events on the 6th of January. If the court ultimately approves Fischer's appeal, it will override hundreds of cases blocking charges on January 6, including that of Trump. This won't affect other 2 charges that Smith directed against former president, conspiring to United States by lying about election loss and plotting to deprive millions of Americans of